Debt suits in Minnesota and the Dakotas routinely violate the FDCPA. Brought to you by yourlegallegup.com, your advantage if you're being sued by debt collectors. Hi, in this video we discuss a process called pocket service or hip pocket service, which is the way some lawsuits are started in Minnesota and the Dakotas. The laws we discuss won't apply to you if you live in another state, but I hope you'll find it interesting and informative as an example of legal reasoning that you may find helpful in whatever you're doing. If you're in Minnesota or the Dakotas and facing a debt lawsuit, you should give careful thought to what we say here. Under the Fair Debt Collection Practices Act, the FDCPA, a debt collector is required to provide written notice of your right to dispute a debt within 5 days of first contacting you, attempting to collect the debt. We often call that the right of verification or dispute. The law also states that a communication in the form of a formal pleading in a civil action shall not be treated as an initial communication under this section. The question we addressed here is whether pocket service, which provides for service of a document that is not yet a civil action, is excluded from the definition of initial communication. In plain English, if a document may become part of a lawsuit, is showing it to a debtor an initial communication under the FDCPA requiring the disclosures of Section 1692Ga. We argue that it is and should. That would make most lawsuits, as they are currently being served in Minnesota and the Dakotas, most debt cases, a violation of the FDCPA. A couple of notes. I've not found a single case discussing this issue. It appears never to have been considered by any court. Also, you can find our complete article at our blog at https://yourlegallegup.com/blog/FDCPA and Minnesota and the Dakotas dash pocket service. Kind of long. I've put that in the about this video section as well. Minnesota and the Dakotas pocket service. Minnesota and the Dakotas have a system of lawsuit initiation that is different from that of all other states, called pocket service. Under this procedure, plaintiffs are permitted to create what looks like lawsuits and petitions and serve them on defendants without ever having filed suit. According to Minnesota law, this commences the action. Then, if the defendant fails to answer in time, the plaintiff can file suit and seek a default judgment. How about that? If the defendant does answer, however, the would-be plaintiff is free to leave the suit unfiled. It's deemed dismissed with prejudice if it isn't filed within a year. But deemed means, as it's obvious, right, that it is not, in fact, dismissed because it was never filed. Given that roughly 85% of debt cases are not answered, but are in fact defaulted, while in almost all of the cases in which people do intelligently defend themselves, the defendants win, pocket service is patently unjust in debt collection cases. This is a farce. Let's look at the actual rule about pleadings not being initial communications. And here it is at 15 U.S.C. Section 1692G, Subpart D. A communication in the form of a formal pleading in a civil action shall not be treated as an initial communication for purposes of subsection A, which is the one that gives you the right to verification. At first blush, it would seem to make a summons not an initial communication, but note that it says a formal pleading in a civil action. The FDCPA does not include a definition of civil action, probably because the term has a widely accepted definition that it is a lawsuit that has been filed in court. With pocket service, no suit has been filed and no suit ever need be filed. It is clearly not a pleading in a civil action, in other words. At most, it's a pleading in what may become one. Under Minnesota law, an action is supposedly commenced by service, that's Rule 3.1, but 15 U.S.C. Section 1692G subpart D is federal law subject to federal interpretation. It's not limited by Minnesota's idea of what it is, and commencement is not necessarily enough to be a lawsuit, right? A plain reading of the language would not accept the commencement outside of court of a suit under Minnesota law is a pleading in an existing lawsuit. That's just common sense. The suit's not existing as a lawsuit. It's merely a possible lawsuit. But it's even clearer if you look at the effect of a contrary reading. If pocket service is not subject to the FDCPA, then you're allowing debt collectors to create the most stressful and unequal communication possible with no oversight. That is litigation. And what scares people more than litigation? There's only death. And not even death, as a matter of fact. I think the survey says more people fear litigation than they fear death. And you're letting the debt collectors engage in continual communications outside of a court's knowledge or oversight for an entire year, free of the FDCPA, if you allow lawsuits commenced by pocket service to escape the initial communication rule. That is exactly the situation on steroids the FDCPA was enacted to put an end to. A bogus reading of what a pleading is under state law should not be allowed to frustrate the purposes of the statute. And I don't believe it will be allowed to either. I encourage everyone in Minnesota or North or South Dakota who has been served a lawsuit by pocket service to consider filing a counterclaim under the FDCPA or a suit in federal court. What is happening is an outrage, really. It should just make you mad to think about it. It makes me mad. One final note. I do think that people are doing this routinely in Minnesota and the Dakotas, but note, this does not make it legal. Just because a lot of people do it and haven't been punished yet doesn't make it legal. It does mean that if you challenge it and get a court to agree with you that pocket service is illegal, you will be putting a big dent in the debt collectors in those states. Of course, we would never want to do that, so pretend you never saw this. Please check my blog for the full article. Whether you're in a pocket service jurisdiction or not, you have an excellent chance to win if you defend yourself against a debt buyer intelligently, and we can help you with that. Helping people protect their rights is what we do. Protect what's yours and don't let the debt collectors rip you off. YourLegalLegUp.com